I'm Patrick Barone of the Barone Defense Firm, and I'd like to discuss with you what happens at a criminal arraignment in a Michigan drunk driving case. The arraignment is the first court hearing that takes place, and it's when the court will advise you about the crime that you're charged with, as well as the possible penalties that you face. Now, if you've retained us before the arraignment, and we've done our job, then we've already advised you as to the potential penalties, including the amount of jail time that you could be facing, the type of driver's license sanctions that may apply, and we also have discussed with you any collateral consequences that you may be facing, such as loss of a job, loss of a professional license, and so forth. So we will go into court and we will tell the court that we waive the formal reading. When the court hears this, they will know that we've done our job, that we've told you what the potential penalties are, you know what the charges are that you're facing, and the court will then enter a plea of not guilty in your behalf. That's part one of the arraignment. Part two of the arraignment is where the court determines what bond and bond conditions are appropriate. There are two parts to the bond. The first is the money, and the second part is the conditions. With regard to the money, in most instances we are able to get what is called a personal recognizance bond for our client. What that means is that you don't have to post any money at all. The court takes your word that you will appear in the future. And of course, if you're standing there voluntarily with us at your side, the court knows that you're a good candidate to appear voluntarily in the future and that no money will be necessary. On the other hand, if you have a criminal record, or if you're facing a particular serious type of drunk driving, such as when an injury has occurred or a death, or you have many prior drunk driving offenses, then the court may see fit to add some type of cash bond. And we will have discussed that with you before you get to court so that you're prepared and you have the money and you're ready to post the bond so that you won't have to spend any time in jail. The next part of the arraignment is to determine what conditions, if any, are necessary to make sure that you're not drinking, and more importantly, that you're not drinking and driving. The court's primary concern in a drunk driving case is to make sure that while you're on their watch, you're not out drunk driving, and God forbid that you would go out and kill someone. So the court is going to be primarily interested in determining what type of monitoring is most appropriate to make sure that you're not drinking and driving. The type of monitoring really is quite broad, the type of monitoring that's available to the court, and it can include anything from your word to staying at home with an alcohol interlock device in your home, on your home phone. Sort of a midway point would be to have some type of random testing, such as breath testing or urine testing, and you may be required to do that on a daily basis, or you may be required to do that on a random basis. There's also something called a scram bracelet, which is the subject of another video, where you can watch and learn more about the scram bracelet, but the scram bracelet is another option, as is a breath alcohol interlock device. That's the type of alcohol interlock that you have to have on your car and that you have to blow into in order to operate the vehicle. So our job with regard to the conditions of bond is to make the conditions as least restrictive, least costly, and least onerous to you, so that you are able to go about your daily business, get to work, and not have too much interference or too much cost.